Okay, on the record in the matter of the people of the state of Michigan versus Dewan May, file number 23-02204 SM, council appearance.
Assistant Prosecutor Petrosky on behalf of the people.
Thank you, Your Honor. Tiffany DeBruin on behalf of Ms. May. She is currently seated out in the hall.
Okay. Today was the date and the time that was set for a jury trial. My understanding is we are prepared to call the jury in, correct?
That's correct, Your Honor.
Yes, Your Honor.
Any matters we need to address between now and the jury impalement?
Yes, Your Honor. There are a couple of matters. Let me grab my file. I apologize. First is that of the video. I believe that prosecution wishes to put into evidence a 20-second snippet of a video, and we are objecting pursuant to MRE 1002 and MRE 106, which indicates that if they wish to introduce that evidence, they must introduce the entire thing. And MRE 1002 indicates that the original must be produced. And I could certainly quote them word for word if the court would prefer.
Okay, did you want to respond to the objection?
Yes, Your Honor. Specifically, in terms of MRE 106, the statute requires that the video be submitted, or if requested, can be submitted in its entirety. And this is the entirety of the video that we have. We only have the evidence that we are able to obtain. This is the full video. I intend to play it start to finish. It is a short video, but the fact that it's a short video shouldn't detract from the fact that it is in its entirety. It was provided to defense counsel, and also, I mean, based off of what is visible in the video, and how things in the video, sorry, I don't want to speak to the content, but basically extending the length of the video based off of what you can see, it would not add anything on either side, because at a certain point, nobody's on screen. So we have the video in its entirety. I will be admitting it in its entirety, and the length of the video, if the jury wants to take that into account when they're judging credibility, they're welcome to do so. But it is the full video.
What makes you take the position that it's not the entire video?
Because, Judge, this came from the complainant, and it's a 20-second snippet. He has videos installed in his house, and you can see that the cameras aren't just rolling this 20 seconds. They are, I imagine they're rolling constantly. So he provided only what he wanted to, and the prosecution indicating that that's what they received, so that's all they can give me. I gave them 3 weeks notice saying we're objecting to this based on the fact that it's just a 20-second snippet. They could have requested the full video from the complaining witness with hours.
So you're saying that the complaining witness has more video?
Correct. My assertion is that he does. He just provided what he wanted.
You know this, or you believe?
I believe.
Okay, because I have videos, and videos, you set the amount of time you want it to run. He could only have a 20-second video because of it takes so much to hold that storage. So I put mine for 30-second clips. It runs down my batteries. So I wouldn't believe that anyone would just keep cameras running in their house or outside their house just indefinitely. And then it doesn't always trigger. So are you aware if your witness or your complainant has additional video and just sliced and gave you a portion or altered section of this video?
So I spoke with the complaining victim in this case about the surveillance video, and from what he indicated to me, at some points, and obviously if this is going to be disputed, but what was told to me was that at certain points during the day, the defendant in this case actually unplugged or disconnected the video. And so he was able to re-record it or attach it for once he realized that it was disconnected. And then I believe he receives it based off of, and I apologize, he's not a very techie person, but this was his understanding to me. I'm
getting very lost right now. Has he altered this video, or is there more video?
From what he's indicated to me, there is not more video, and he did not alter.
To the extent that he didn't alter the video, I'll hold the objection in abeyance. I think we probably need the witness on the stand. And then when they're laying the foundation, you can voir dire. And we can get him under oath to find out if this is a video that he may be altered or shortened, if there's additional footage that should have been turned over. And then I'll make a ruling at that time.
And Your Honor, is that something we're going to do in front of the jury?
As to laying the foundation to admit the evidence?
Yes, Your Honor.
Absolutely.
Yes, Judge. And the second, I guess the second preliminary issue that we have is I informed Ms. Petrosky that I was seeking her assistance in subpoenaing 2 witnesses. I do not know if they are present. I haven't called the court or the hallway for them. If they are not present, I'll be requesting the jury instruction that indicates that they are not present, they should have been produced by the prosecution, and their absence should be construed appropriately.
Okay. And were those witnesses subpoenaed?
They were, but it was later than I would have liked.
Okay. When were they subpoenaed?
Friday.
When did you notify the prosecutor's office that you wanted them subpoenaed?
December 14th.
To the extent that your witnesses are not here, that jury instruction will be added.
Yes, Your Honor.
Any additional matters?
No, Your Honor.
Okay, any matters for you?
Nothing with people.
Okay, I will adjourn on this one until the time that the jury can be called in.
Yes, Your Honor.
Thank you. Okay, final pretrial. Let's see. What's going on with Wilson? They just logged in, so is Mr. Lee here today, or is just Mr. Lee here today?
Yes, he is.
Oh, he's in a breakout room.
Vote.
I don't know what you want.
And yourself?
I'm pretty good. Are you ready with many of the individuals that are on the screen here?
As Mr. Trusty was mentioning, we're ready with Alvarez, we're ready with Lucas. Is that Mayo Wilson there in ICJ?
It is Wilson and ICJ. Okay, we adjourned that one. What happened with Lewis and Jones? For final pretrials.
So there are two files for Lewis. The domestic violence file, the victim failed to appear, but the lying to a peace officer file, given that the complaining victim is an officer, he was not subpoenaed, but we.
Okay.
And that, excuse me, that case also, I believe, there's going to be plea on.
Okay, Lewis is present.
This is Jordan Lewis.
Okay. We're ready to proceed on that.
Yes.
On the record in the matters of the people of the state of Michigan versus Jordan Michael Lewis, file number 16-02054 and 22-03199. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Riley on behalf of Mr. Lewis.
Okay, Mr. Lewis, how are you?
I'm doing good. How are you doing today?
I'm doing well, thank you. Today was the date and time set for final pretrials in both files. One is for a domestic violence, and the 2016 file is for lying to a peace officer. My understanding is that we don't have a complaining witness for the file number 22-03199. Is that correct?
That's correct, Your Honor.
Okay. The motion to dismiss is granted. The case will be dismissed without prejudice. That means the people have the right to reissue the case against you within the statutory time frame. Okay?
Okay, that's fine.
We'll get you a copy of a dismissal. And then as it relates to file number 16-02054, that is scheduled for jury trial February 20th, 8 a.m. in person at the court. But how are we proceeding on that?
It's my understanding that defendant would be accepting the offer in this case.
That is correct.
Thank you. Thank you. Okay, it says here that the defendant is going to plead guilty as charged as a killaboo to fines and costs only. No contest plea due to lack of memory. Accurate, sir? Accurate, sir? Raise your right hand. The other right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Okay. The Vice of Rights and Plea Information sheet, it has today's date on it. Is that your signature?
Yes, ma'am.
Did you read this document?
Yes, ma'am.
I understand the rights listed here.
Yes, Your Honor.
Do you have any questions about these rights?
No, Your Honor.
And are you willing to give up each of these rights today in order to plead guilty?
Yes, Your Honor.
You have the right to proceed to trial. You have the right to a jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor prove your guilt at your jury trial by proving each element beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. And you have the right to confront and cross-examine any witness the prosecutor calls to testify at your trial. You also have the right to have witnesses subpoenaed to testify on your own behalf or to present evidence that you believe show a defense to the charge being brought against you. And you wish to waive each of those rights, sir?
Yes, Your Honor.
Does anybody make any threats to you to get you to waive those rights and plead guilty?
No, Your Honor.
Has any promises being made to you?
No, Your Honor.
You don't remember this incident?
I don't, ma'am.
I don't see why you would. It's from 2016. So that makes sense. You understand that a no contest plea could result in a conviction that you may need to report to your employer.
Yes, Your Honor.
It also could have impact on travel or immigration status that you may be seeking.
Yes, Your Honor.
As to account one of line 2, peace officer, a serious misdemeanor investigation. Misdemeanor maximum penalty 90 days and or $500 in fines. How do you plead?
Guilty. No contest.
Police report.
Should email one to you.
Send it.
I did.
I've not yet received it. I'll go off the record and call the next case until it comes through. Okay, Mr. Lee, you said you were ready with,
Mr. Lucas, Mr. Gonzalez,
where's DeQuandrick Jones?
I'm sorry,
Where's DeQuandrick Jones? Here,
it's my claims night.
okay. Yeah, it's your bench warrant. Oh, Mr. Riley, you just came through.
No.
We're also prepared to proceed on Mr. Mayo Wilson.
Okay, thank you. Okay, back on the record in the matter versus Jordan Lewis. I do have a police report now. Let's see. This is an incident report number LLA 1604080034885. Incident date April 7th, 2016, at approximately 17:30 hours at the area of 401 West Greenlawn Ave, Lansing, Michigan, Ingham County, state of Michigan. Again, let's see. Looks like officer from Lansing Police Department, Nicholas Zuber, was dispatched to Greenlawn, or that address at the time being McLaren Hospital for a late assault. The victim had been assaulted for 716 at Caddis Station. By her ex-boyfriend. Typically, when I take a no contest plea, I need the highlighted portion, so I need to know what's supposed to be
So,
factual basis portion. I see the statement taken from Jordan Lewis. Is that the area I'm supposed to be?
that is the false statement.
Okay. A witness statement was taken by the defendant, Jordan Lewis, stated that they were all at CATA and the accused showed up. The witness stated that the accused began pounding on the wall of the CATA station. The witness stated the victim went outside to confront the accused. Jordan Lewis stated that the accused then slapped the victim in the face and hit her in the stomach. Witness stated the accused also grabbed the victim's arm and twisted it. Mr. Lewis stated he then stepped in and got the victim away from the accused so they could leave. Mr. Lewis then stated that the victim is pregnant with someone else's child, and the victim complained of pain to her stomach and arm. Witness, Mr. Lewis mentioned that the victim may have lost pregnancy. There was a follow-up. After hearing the statement from witness Lewis, officer went back to speak with the victim again and asked her about the pregnancy. The victim was very vague and refused to talk about it. Victim stated she did not want to deal with it and needed to speak with her personal doctor. The victim stated that after doing that, if needed, she would contact the police. What's the false statement?
Further down on that page, the detective reviews a security video from the gas station that shows the victim and Mr. Lewis's statements.
Page is that on?
That's the page 6 of the PDF for the bottom.
Okay, see, later down on page 6, under a detective's action, responding officer reviewed the original incident report with the attached photograph and noted that this was the same incident that was reported by Matthew Walter as the victim in complaint number ending 3467. Responding officer reviewed the complaint, prepared a packet for Graham County prosecutor, and dropped it off for review on April 8th, 2016 at approximately 11:20. Responding officer had received a copy of the CATA security video of the entire incident from CATA security officer Michael Simpson. Responding officer reviewed the security video several times, which captures the entire incident, and appears that at no time the listed accused Matthew Walter strikes the victim Faith Mohart. Security video shows the victim is actually Matthew Walter and the accused is Faith Mohart. Any additional factual basis?
Not from the defense room.
Court is satisfied with the factual basis. I find the reason for the no contest plea to be appropriate. I find your plea to be made freely, voluntarily, and intelligently. Your fine is $300 and you pay.
At the end of this month.
You're gonna pay in full?
Yes, your honor. I got a new job, so.
Okay. You make payment at the criminal traffic window, or you can make payment online, okay?
Thank you.
No problem. Any additional matters for the record?
Nothing from the people.
No, yeah.
You're all set, sir.
Thank you, your honor.
On the record, in the matter of the people of the state of Michigan versus Andre Lucas, file number 23-03034. Council appearance.
Assistant Prosecutor Peter Petrowski on behalf of the people.
Assistant Public Defender John Lee on behalf of Andre Lucas.
Mr. Lucas, can you hear me?
Yes, ma'am.
Oh, today was the date and the time that was set for a plea. I have one count of electronic communication and a count two of domestic violence. Let's see. The offer was for the defendant to plead to count two of domestic violence, and the people would dismiss count one. There was no objection to sentencing of under 769.4A. And at the time of his last court appearance, he did have some questions during his plea. Were you able to get your questions answered, Mr. Lucas?
Yes, ma'am.
Okay. And are we still continuing with that plea offer?
Yes, we are, Your Honor.
You want to accept that, Mr. Lucas?
Yes, ma'am.
Raise your right hand. I don't know if your camera switched the other way, but okay. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hands down. Okay, you have several rights, sir, that you would need to give up in order to enter a guilty plea to count two of domestic violence. One is the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to require the prosecutor prove your guilt at a jury trial. They do that by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have that silence be used against you. You have the right to confront your accuser in court and cross-examine or question them. You have the right to have witnesses subpoenaed to testify on your own behalf. You have the right to present evidence at trial that you believe further a defense to the charge being brought against you. And you have the right to remain silent at trial and not have that silence be used against you. Are you willing to give up each of those rights today?
Yes, ma'am.
Has anybody threatened you to get you to want to give those rights up?
No, ma'am.
Any promises being made to you in exchange for you giving up those rights and entering a guilty plea?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report a conviction on a future job application.
Yes, ma'am.
A guilty plea could also have impact on your ability to travel certain places or immigration status that you may be seeking.
Okay, that's fine.
You understand that?
Yes, ma'am.
Okay, and then there's no objection to 769.4A, which would be a special status that you could be granted if eligible, but that's not a promise that you're going to get that status. You understand that as well?
Yes, ma'am.
Okay, as to count two of domestic violence, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Lucas, on or about October 3rd, 2023, were you at the address of 5132 South Pennsylvania Avenue, room 9?
I was.
Okay, and that's in the city of Lansing, the county of Ingham, state of Michigan, correct?
Correct.
And were you at that time in the presence of Lorraine Mays?
Yes.
And you and Miss Mays had an argument, correct?
Correct.
And during that argument, you pushed her?
I did.
And when you pushed her, she fell down, correct?
Correct.
No further questions, Your Honor.
Pushing her in self-defense?
Excuse me?
Were you pushing her in self-defense?
Yes.
You were pushing her in self-defense?
Yes, ma'am.
Okay. Any other questions?
Mr. Lucas, were you the first person to assault, the victim in this case.
Huh?
Did you make contact first or did the victim make contact?
I was approached. Like she was in my bubble, so I just pushed her.
She was in your what?
My personal space.
Is that what you mean about you were in
Did I what?
self-defense? Is that what you mean? Is that what you mean about you assaulted her in self-defense?
I said that you asked me if it was in self-defense. I said she got inside. She got in my face. I pushed her back. Excuse me.
Did she threaten you?
Huh?
Did she threaten you?
Yeah, with her parents. But other than that, I mean,
Um,
I wouldn't
we're
say.
satisfied.
I'm not satisfied. I'm not following.
Might I redirect you?
Please.
Mr. Lucas, self-defense is a complete defense to assault and battery. So if you claim that you were acting in self-defense, you cannot put a guilty plea on the record because self-defense is a complete defense to those actions. So what the court is trying to ascertain is what you mean by self-defense. By self-defense, do you mean that you were attacked? Were you attacked and responding to an attack?
No.
Okay. Did she put her hands on you?
She attempted to.
Okay. Did she strike you before you pushed her?
There was somebody else talking. I could barely hear you.
Did she strike you before you pushed her?
No, I didn't let her get a chance to strike me. Like when we got the argument, we both like she got in my face, and I pushed her. I wasn't going to give her a chance to try to hit me.
Got you. So you guys were arguing. She got close to you, and you pushed her. Correct?
Correct.
Thank you.
Okay. And you said you were, when you were questioned by your attorney just now, and you asked if she had assault, you were asked if she assaulted. There's some feedback going on, and it's not coming from the court. Okay, so I know you said there's someone else talking, Mr. Lucas. I just want to let you know that's not coming from the court. It's a technical issue, and I don't know what it is.
Okay.
I think it's from the jail. I'm going to put Mr. Wilson in a private meeting room. Okay. When your attorney questioned you and asked you if she had assaulted you, you said that she tried to assault you, and is that your position?
No, I said that I didn't give her a chance to. Like once she
Okay.
once we got in each other's face, that like I immediately pushed her away from me.
Okay, so she approached you, you all were arguing, that's correct?
Correct.
Okay, did she raise her hand at you at any time when she approached?
Honestly, everything happened so fast. The only thing I remember is her getting close to me and I pushed her.
Okay, sounds good. Any additional factual basis?
Okay.
Okay, the court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing February 27th, 2024 at 9 o'clock in the morning. You need to go meet with our probation department in person this week, no later than this Thursday, which is January 17th. And you need to be there by 9:30, okay?
One second, I'm putting that down.
No problem. I'm sorry, it should be January 11th. I gave you the right date. You need to appear by January 11th.
Okay, let me fix that then. You said no later than 9:30?
That's correct.
Okay.
They'll get you prepared for your pre-sentence interview, so they can provide the court with a recommendation as to how you are to be sentenced, okay?
Where do I go for that?
City Hall on the 5th floor to the probation department.
City Hall, 5th Ward.
5th floor, the probation department.
Will I get something in the mail?
You will not.
Okay, I just need a, so 6th Ward, Capital. What was it?
5th floor, City Hall. You can just come to City Hall and tell them you gotta go to probation. They'll tell you where to go.
Okay, and that's on the 11th. And then when's my next court date?
Then your sentencing is gonna be February 27th at 9 a.m.
Okay,
All right, do you have any questions?
no, ma'am.
Okay, you're all set for today.
All right, thank you.
So he submitted the paperwork to adjourn this. So
Bad things, I don't come in, I go to jail.
which I totally, yes.
Nobody called. I mean, well,
I'm very sorry.
Well, I'm just-
That would just
I'm just telling you that I was here, I'm leaving.
appreciate that. I'll be for.
Mr. Wallace, let me get you a new date before you leave, so you already know.
This, the last one.
Sir, what's your name? Have a seat, please.
He's out.
You can appear via Zoom, but I'll probably be in the middle of the trial.
Okay.
Thank you. Oh, okay. No, I was looking for Wetzel. Oh, that was the one they was stick to adjourn. Mr. Wallace? Yeah. You're Mr. Jack Wallace?
Yes, ma'am.
You have an attorney representing you?
I guess the
Okay,
court didn't contact him or something.
the court didn't who?
Court didn't contact him.
That's not the truth. This matter was set for trial a long time ago. It was a different attorney that was on there.
That was 2 years ago.
I recognize that, but the public defender's office was notified. Don't come in the court and approach the prosecutor about that issue because you do have an
I just want
attorney.
to let her know that.
I don't want you coming in here approaching the prosecutor. You have an attorney. You don't speak directly to the prosecutor. You speak to your attorney.
I just don't want to go to jail because.
You're not gonna go to jail because you're in court today.
But nobody knew I was here. I'm just letting her know that.
We,
I'm gonna leave. I just want to let her know that I did show up. When he does them. if
your
I go to
attorney
jail-
requested, your attorney notified the court in writing that he wanted a new date. So he should have told you that when he did that.
This is. It's still 1,125. It's not, it is what it is, but I understand.
So don't approach her that she didn't call you. Your attorney was supposed to call you.
That's not what I wanted to let her know. That's it.
I recognize that. She was not looking for you. Okay, so when you come in, you check in with a court officer, okay, not with the prosecutor. You understand that?
Who's the court
I
officer?
have two over here. There's two.
This was all full when I was sitting over here. That's what happened last time. I understand that. I talked to two people out there.
I recognize you talked to two people. I don't know if you talked to a court officer though.
Your Honor, I called his name 3 times. He didn't appear at 8 o'clock.
What time did you get here?
I got here, I think 8:30.
Exactly. You're supposed to be here at 8. So don't come in here aggressive and acting like she didn't notify you. When you weren't even here when you were supposed to be here, number one. Number two, you have an attorney and your attorney was supposed to tell you didn't have to come today. He requested a new date in writing. Filed it with the court, I signed it, okay? You got a copy of that in your hand. You talk to your attorney in the future. Don't talk directly to the prosecutor. That's for your own protection. Do you understand that?
I just wanted to make it.
I don't care what you want to make. Have a good day, sir. Okay, did Mr. Lee need to speak with Mr. Wilson? I don't know who Mr. Lee went. Mr. Raleigh, do you have someone? You ready with Hinton?
Yes.
On the record in the matter of the people of the state of Michigan versus Raphael Hinton, file number 22-01434, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Riley on behalf of Mr. Hinton.
Okay, Mr. Hinton, today was the date and the time that was set for a pretrial on 1 count of assault and battery. Was there an offer on this?
There is not currently.
Okay, how do you want to proceed?
At this time, we would ask that this case be set for final pretrial and trial date.
Set the matter for final pretrial. We will not be reading the defendant here for that purpose, okay? He can appear via polygon. Final pretrial, February 20th at 8. February 20th at 8. And jury trial, February 23rd. Jury trial will be February 27th at 8 in person. Do you have any questions today, Mr. Hinton?
No, ma'am, Your Honor.
Okay, any additional matters for today's record?
Nothing for the people, Your Honor.
No, Your Honor.
Okay, you're all set, sir. Thank you.
Thank you.
You're welcome. Mr. Lee, you said you had Alvarez?
Yes, ma'am.
Okay. On the record in the matter of the people of the state of Michigan versus Amanda K. Alvarez, file number 23-02819, 20 and 21, council appearances.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Amanda Alvarez.
Okay, today was the date Ms. Alvarez set for pre-trials, or please, actually, I have a dog at large, dog bite, and a vicious dog. Council, how are we proceeding?
Thank you, Your Honor. Ms. Alvarez would be accepting a plea offer in this case. she would be accepting responsibility for a count of disturbing the peace, which is a civil infraction, and paying restitution in the amount of $186.59. And we would be dismissing all of the counts. Mayor.
Yes. Thank you. Okay, is that correct, Ms. Alvarez?
Yes. Yes, ma'am, that is.
Okay, which matter does she owe restitution on?
The dog bite, Chris.
Yeah, the dog.
Okay, so I will amend file number ending in 820 to disturbing the peace of the defendant accepts responsibility. The fine is $75. Plus there is restitution in the amount of $186.59. I need a restitution form as well. When can you make payment on that, Ms. Alvarez?
It would be $50 this Friday.
Will you make your next payment?
I make weekly payments, so every 2 weeks.
Okay. I'll note that you'll make a payment of $50 this Friday, and then you're gonna pay $50 bi-weekly?
That is correct, Your.
Okay, you can make payment at the court website. Okay, or you can come up and make payment at the criminal traffic counter, okay?
Okay.
Do you have any questions?
No, I do not.
Any additional matters for the record, counsel?
Nothing for the people, Your Honor.
Nothing for the defense, thank you.
You're all set, ma'am. They probably are. Yeah. That's what they usually, because I think King County Animal Control usually does these. Are we ready, Ms. Wilson? I'm sorry? There's two Wilsons. There was a final pretrial Wilson. Okay, on the record in the matter of the people of the state of Michigan versus 23-03393, counsel appearance.
Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Mayo Wilson.
This is Mayo Wilson Jr., correct?
Yes, ma'am.
Okay, today was the date and the time that was set for final pretrial one count of domestic violence. Do we have the witness here?
No, the witness is not present.
Counsel, how do you want to proceed?
Defense makes a motion, Your Honor, to dismiss since prosecution is unable to proceed.
Your motion to dismiss is granted without prejudice. We'll get you a copy of the dismissal, Mr. Wilson. That means that people have the right to reissue this charge against you within the statutory time frame. Okay?
Yes, ma'am.
Is he being held on anything else other than this? He had a bond of 2,500, 10%. I don't see that it's posted though.
He does have some other cases.
Okay.
Including a felony.
Sounds good. Unless you have questions for us, Mr. Wilson, you're all set for today.
Thank you.
Paige. Okay, are we ready with, oh, is Glenn and Jamie Irby here?
We are here. But Mr. Campbell had to step out for a minute. So if you want to skip over us for a second. is.
You said you sent it over. Okay, he's not here right now. Okay, so. Pass it this way.
That's fine. That's what that is.
Marissa Kubari here. Okay, on the record in the matter of the people of the state of Michigan versus Marissa Carberry, file number 20-01754, council appearance.
Prosecutor, on behalf of the people.
Jacob Riley on behalf of Ms. Carver.
Okay, how are you, Ms. Carberry?
I'm well, how are you?
I'm doing well, thank you. Today was the date and the time that was set for sentencing. I have a pre-sentence report. It was prepared on December 21st. Raleigh, you did receive a copy of that,
Yes.
and did you go over it with your client?
Yes.
Any need to make updates, corrections, or deletions?
We have none.
You can make out.
Thank you, Your Honor. I do think the recommendations of the report are fair and appropriate. Certainly, Ms. Carver acknowledges that she has issues with alcohol that she needs to address. It's gotten to a point where they're seriously affecting her life, and she certainly does not want to be back in court. Additional probation with outpatient treatment would be appropriate.
Okay, did your client want to make a statement at all? I reviewed the pre-sentence report and the recommendation. The report opines that you did score criteria for a moderate alcohol use disorder and moderate cannabis use disorder. You met 5 of the 11 diagnostic criteria for alcohol, 4 out of 11 for cannabis. Then in a review of your prior criminal history, I see more than one interaction with the criminal justice system that is akin to this type of behavior. So I think I agree with probation and their assessment that you could benefit from a course of supervision by the court and some substance abuse treatment. With that being said, I'm going to adopt the recommendations. Your sentence is 8 months probation. While on probation, you're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription, okay? If you do have a medical marijuana card, you need to provide a copy of that to probation as well. You understand that?
Yes.
Okay, you will be required to submit to random preliminary breath testing and or urinalysis testing. You have to pay the cost of that, okay, ma'am?
Okay.
You're not to be at any bars or any nightclubs while you're on probation.
Okay.
You need to attend a victim impact panel within 90 days and provide verification.
Okay.
And I'm going to order that you participate in outpatient substance abuse treatment. You'll maintain your employment while on probation. Do you have any questions?
No, ma'am.
The $30 per month oversight fee that you're responsible for.
Okay.
There's a $75 crime victim rights fee that per statute must be assessed. There's a $50 state minimum cost, which per statute must be assessed. Prosecutor recovery fee is $120. It looks like you owe $90 for an assessment. See anything from Michigan State University Police Department for OWI cost recovery, so that will not be assessed. It's a $30 per month oversight fee for probation that you're responsible for. If you do 8 months, that's $240. I'm gonna waive discretionary fines and costs at this time.
Your Honor, and I apologize if the court hasn't received it, but we do have a, the OWI restitution request form from the Michigan State Police. In the amount, the total cost would be $332.95.
Was that provided to defense counsel?
It was not,
It was.
I believe it was noted in the pre-sentence report that none was provided to the probation department.
Okay, I need to see their cost recovery form, and he would need a copy as well. Oh, you know what? I take that back. There is one in the file. $332.95 was attached to my packet. You didn't have one in your discovery.
No,
I just sent a group email to everybody, so you should receive it just a second.
Thank you. Okay, so OWI cost recovery. Of $332.92 will be assessed to be paid to MSU police.
I did receive that, Your Honor.
So your total fines and costs are $907.95. You'll make monthly payments on that, okay?
Okay.
Do you have any questions? Mr. Raleigh, I have a form for her to review and sign here. This form goes over your rights as it relates to when you would have the right to request early discharge from probation. You do have the right to request early discharge once you've completed half the original term ordered by the court, so long as you've not had any violations within the 90 days preceding that request. That request can be made in one of two ways. The probation department can make the request on their own. They would serve a copy of that request on the prosecutor's office. The prosecutor would have 14 days from the receipt of that request to file a written objection to your early discharge. You can make your own request by using the court's MC 512 form. That's a form you can get on the website, or you can get it from your probation officer. You would file a copy of that with your probation officer, and then also with the prosecuting attorney. The prosecutor again has 14 days to respond with any objections in writing. If a hearing is scheduled to address early discharge, you have the right to hire an attorney to represent you at that hearing. You do not have the right to court-appointed counsel for a hearing for early discharge, okay?
Okay.
Do you have any questions?
No.
Okay, you can give me that back. When you leave here, you'll go down to probation and check in with them.
Okay.
And then they will, in the near future, prepare an order consistent with my judgment as to how you are to be sentenced, okay?
Okay.
Do you have any questions?
Is probation on the 5th floor?
It's on the 5th floor. Actually, can I have the main file back over here? It's on the 5th floor, and we'll have someone accompanying you down there in just a minute, okay? Any additional matters for the record, counsel?
I think thank you for your honor.
Nothing from the defense room.
You're all set, ma'am. Okay, that's better. On the record in the matter of the people of the state of Michigan versus Glenn Ray Irby and Jamie K. Irby, I have phone number 23-03349 and 23-03350. Counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Morning, Your Honor. Sean Campbell on behalf of the Mr. and Mrs. Irby.
Okay, Mr. Campbell, we don't have an appearance from you.
I have a fax verification December 15th. That was faxed to 54A District Court.
Okay, well,
But
we don't have it.
I can resend it.
Okay, today was the date and the time that was set for pre-trials on both matters, dog malicious destruction of property. Did you receive discovery?
Yes, I did.
Okay, how do you want to proceed?
I just had two follow-up items with the prosecutor. If I could have a breakout room, possibly.
Probably not, because I'm trying to get this docket clear because we have a jury coming in. So
All right,
that's something you're gonna have to do.
understand.
I'm
can
gonna
we
just give you a new date.
Okay, thanks.
February 6th. February 6th at 10 work for you?
That should work.
Okay, so we'll reschedule it to then, and then Ms. Petrosky should be available outside of the court time to discuss the issues with you.
All right, thank you.
No problem. Any additional matters for today's record?
Nothing for the people. Thank you.
None, Your Honor.
We're all set. Okay, let's see. Who is UB?
Andre Brown.
Okay, thank you. Do we have Joseph Ellenboss present? I'm not seeing him. If he is present. Where did Mr. Lee go?
Oh, I'm excited to do it.
Okay, on the record, in the matter of the people of the state of Michigan versus Devin Wilson, file number 23-01258. Devin Wilson, are you present?
Yes, ma'am.
Okay, Mr. Wilson, today was the date that was set for show cause because you owe some fines and costs. You were here back in November and your sentence was for fines and costs of $250 plus a $75 crime victim rights and $50 state minimum cost. We referred this to collections because you at the time were housed at Bear River, and we just needed to get you on a payment plan.
Okay. Currently at, what was that?
I'm trying to figure out if you're able to make payments at this time.
Yes, I can make a payment today. I have a few job interviews. I just left Bear River to a transitional housing. But I will be able to make $50 of a payment today. And then I can get on a payment plan with collections.
Okay, well, I'm gonna put you on a payment plan now. You're gonna make payment of $50 today, and when can you make your next payment? Do you think 30 days is enough time?
Yes, ma'am.
Okay, will you be making a $50 payment then?
Yes.
Okay. So I'll note here, you'll pay $50 today, and then you'll pay $50 once a month until paid in full, okay?
Okay, sounds good.
Thank you, you're all set, sir. Do you know if Joseph Ellenboss is out there?
Are you on Joseph Ellenboss? Okay. Yeah.
Hey, excuse me. Do I still have court today?
Yes, you do, sir.
All right, thank you.
Who's representing Mr. Gonzalez? Is it Mr. Lee?
I know it's not me.
I'm not sure where Mr. Lee is. So what's your name?
My name is Capone, last name Williams.
Oh, Mr. Lee is here. Mr. Lee,
Yes, ma'am.
are you ready with Mr. Gonzalez?
Yes.
On the record in the matter of the people of the state of Michigan versus Sergio Gonzalez, file number 23-01205. Appearance, please.
Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Mr. Sergio Gonzalez.
Okay, Mr. Gonzalez, today was the date that was set for sentencing. I have a pre-sentence report that was dated for December 13th. Mr. Lee, did you get that report and did you go over it with your client?
I did, and yes, I went over it with him.
And you need to make corrections, updates, or deletions.
No corrections, updates, or deletions.
You can make allocation.
Thank you, Your Honor. Mr. Gonzalez is a young man who is now 21 years old and an adult. He realizes that some of the ways he has been acting as a young man needs to change. He has a child on the way. He is enrolled in a GED program to try to finish his high school diploma. He has been participating in a cognitive behavioral therapy program because he recognizes that he needs to practice greater self-control and to be a better support for his child's mother and his child that is on the way. So he's growing up around him, and he's accepting responsibility here. And we're just asking the court if they would adopt the recommendations of the PSI and sentence Mr. Gonzalez to time served, which I believe is 76 days.
Mr. Gonzalez, did you want to make a statement?
No, Your Honor.
Sentenced to 76 days, Ingham County Jail credit time served. We're all set.
Thank you. Have a good day.
Same to you. John Warfield, present.
Yes, Your Honor.
Ready, Mr. Warfield?
I do need to speak with him.
Let's see. Who else is here? What about Capone William?
John Warfield is here.
I see that you're here, sir. Thank you.
Oh, I'm sorry.
You
I
ready?
apologize.
Capone Williams, are you ready on his file?
I am not here.
What about Manuela Shura?
I called, I do not see Manuela here.
She's on Zoom.
Oh, yes, I do need to speak with her. I do have Jasmine Flowers here and Noel Jackson here as well in person.
What about Andrew Brown?
That's my client, Your Honor.
You ready on Andrew Brown?
See,
He's on Zoom.
okay. I think we're right on.
Okay, and I don't see your clients that you're ready on in the courtroom. I thought you said you had some people that you were ready on.
I do, I'll go on the hallway.
Okay, on the record in the matter, the people of the state of Michigan versus Andrew Brown. File number 23-3628, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Brown on behalf of Mr. Brown.
Mr. Brown, is it pronounced Andrea or Andre?
Andre,
Andre, and is it Brown the third?
that's correct.
Okay, very good. Today was the date and the time that was set for a pretrial 1 count of domestic violence. Was there an offer on this?
This file our offer would be to for defendant to plead guilty as charged to domestic violence, and we would not object to 769-4A.
Mr. Rowley, how do you want to proceed?
This time, I think we'll be asking this matter be set for final trial dates.
February 20th. Jury trial, February 27th. Final pre-trial, February 20th, in person at the court at 8 a.m. And then your jury trial will be scheduled for February 27th, in person at the court, 8 a.m. Okay? Is this bond really 210%?
There's one additional issue, Your Honor, with me.
Yes.
My client has been fitted with the GPS tether. It is causing him some discomfort and hardship. I don't know that there's a specific reason that he needs to have a GPS tether. I don't believe he has violated his bond conditions in any way or shown himself to be a dangerous individual. So our request would be that he be allowed to remove that tether and just continue on bond.
Couldn't speak to any of that because I don't even have an affidavit for probable cause in this file for some reason. All I have is that he was placed on a 210% bond, which would indicate to me that there's not a real threat to public safety. That was, but I'll let the prosecutor respond with any information I may not have.
As far as information that we received, we haven't heard anything about any sort of bond violations. We would not be objecting to the removal of GPS tether, but we would ask that the dual contact order remain in place. And I'm not sure how you don't have the affidavit of probable cause, so I will try to figure that out.
Let's see. Okay, I will remove the GPS tether.
Thank you.
You're welcome. You need to go back to Ingham County in Mason to have that removed, okay?
And I can-
Otherwise, your bond will continue including the no contact order, okay?
Okay.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Okay, we'll see you on February 20th, sir.
Thank you.
Mr. Lee, I thought you were getting your people that were ready.
I just had to touch base with the prosecutor.
Okay, well, I'm gonna go to jury instructions and.
Looks like the mic's off. No, they unmuted it. Now I'm in the courtroom. Yeah, there's a lot of people. I don't think she's in there yet. Hello?
I see two devices with the name Nikki Lopez. Which one are you using?
I'm Nikki Lopez, the one that is here.
Okay, thank you. Do you know who the other guy is?
No,
Okay.
Nikki Galaxy.
I don't know why that had my name on it.
All right, thank you, Ms. Lopez.
Did you put my name in there?
Yes.
Bro. Do you know who she is?
Yep, you did.
Did we find if Mr. Warfield was here? I don't know.
Yes, I'm here.
Already, Mr. Warfield.
Yes, we are. Thank you.
How are you doing?
How are you? Okay, on the record in the matter of the people of the state of Michigan versus John Warfield, file number is 23-03187, counsel appearance.
Prosecutor Trustee, on behalf of the people.
Assistant Public Defender John Lee on behalf of John Warfield.
Say was the date that was set for sentencing. I don't believe that I referred this to, oh, I did refer this to probation. Okay, I do have a report. It was prepared on the 4th of January. Did you get a copy of that?
I did, Your Honor.
You did, Your Honor.
Okay, we did not receive a victim impact statement. Is there any reason to make updates, corrections, or deletions?
No updates, corrections, or deletions, Your Honor.
None from the people.
Who can make allocution?
Thank you. Mr. Warfield is somebody who has accepted responsibility in this case. He admits that he has suffered from alcohol dependency issues and is excited to get an outpatient substance abuse program. He has taken some positive steps in his life. Since his plea, he has been actively looking for a job. He interviewed yesterday with a temp agency and has an interview tomorrow at Bell Tires. So he is actively looking for employment. He has completed a program, a probation program in the past, and believes that he will be successful in probation here as well, Your Honor. We're asking the court to adopt the recommendations of the pre-sentence report.
Thank you. When did you want to make a statement for himself?
Mr. Warfield, would you like to make a statement?
No, I think you said everything perfectly. I just think that I can do this program properly because I've done it once over before, which sounds sad, but it's true. So I think I actually really am excited to do this again because last time I did it, I prospered extremely well and it elevated my life a lot. So I would actually I'm really excited to do it again, to be honest, which just sounds funny, but thank you.
Okay, thank you. I reviewed the pre-sentence report and the recommendation, which is for a term of probation. I'm happy to hear that you are excited to elevate your life. I don't know that we want to create a pattern where we're continuously on probation so that we can get that elevation. We hope that this term of probation will put you on a better path so that you'll make better decisions that won't place you before the court, and that you'll use other things to elevate your life, like employment and education and activities in the community that enrich our environment and our society. And
Yeah,
so
I actually
that's the goal.
Yeah, I was actually pursuing a career in fitness training.
That's exciting, and that is hopefully something that you'll continue to pursue. I'm going to adopt the recommendation. The recommendation is for 6 months probation. While on probation, I'm going to continue the no contact order with Meredith Clark. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance without a valid prescription. You are required to submit to random preliminary breath testing and/or urinalysis testing. You're responsible for the cost associated with that. Do you understand so far?
Yes, ma'am.
I am going to order that you attend a 12-step meeting as directed by probation.
Like the AA?
Yeah, that could be an option, yes, and you'll discuss that further with your probation officer, okay?
Of course. Thank you.
No problem. You will obtain employment and provide verification of that to your probation officer as well.
Okay.
There's a $30 per month oversight fee that you're responsible for probation.
Okay.
$75 crime victim rights fee will be assessed, plus a $50 state minimum cost will be assessed. I'm gonna waive discretionary fines and costs. Your total fines will be $305, and you'll make monthly payments on that, okay?
Of course. Thank you.
Thank you. Do you have any questions for the court at this time?
Yeah, so about my tether, is that gonna have to stay on for the next 6 months or?
No, I'm not ordering tether to stay on. You're no longer gonna be on bond because this case is being disposed of by way of probation. So you're going to be able to go down to Ingham County and have that tether removed.
Can I do that as of today, or does that have to be tomorrow, or?
You can do that today.
Oh, that would be amazing. It is such a burden. I hope you never have to do it.
I don't intend to.
Of course not.
Okay. With that being said, there's an advice of rights as to probation. States here, you've been placed on a term of probation in 54A District Court. Probation conditions are individually tailored and specific to address your assessed risks and needs, except for domestic violence, criminal, sex crime, stalking offenses, or offense where defense but guilty but mentally ill was asserted. You may be eligible for early discharge from probation. In order to be eligible, you need to complete half the original term ordered by the judge. In this case, it will be 3 months, and you could not have had any violations within that 3 months, okay?
That sounds amazing.
Okay, you can make that request by using the court's MC 512 form. And you would file a copy of that request on the probation officer and the prosecuting attorney. The prosecuting attorney would then have 14 days to respond in writing. If I set up for a hearing, you can hire an attorney. You do not have a right to court-appointed counsel to represent you for a hearing for early discharge. Do you have any questions about those rights?
I do not.
Okay, you check in with our probation department within the next 2 days to make sure they have accurate contact information with you, and they will get a judgment of sentence prepared for you to review and sign, okay?
I appreciate you so much.
Thank you. You have a good day, sir.
Thank you. You drive safe out there because it's not looking really fun. So.
Okay, sounds good. Thank you.
Thank you.
Let's see. Are we ready with Mr. Capone Williams?
Yes, ma'am.
On the record, in the matter of the people of the state of Michigan versus Capone Williams, file number 23-01865. Appearance, please.
This is the prosecutor, Kate Kosowski, on behalf of the people.
Assistant Public Defender John Lee on behalf of Capone Williams, who is in the courtroom and standing to my right.
Okay, Mr. Williams, today's the date set for pretrial and domestic violence. I'm going to assume there was no offer and we're setting this. Is that what's going on?
Yes.
February 20th, pretrial at 8. And February 27th. Final pretrial in person at the court, February 20th at 8 a.m. And your jury trial will be scheduled for February 27th in person at 8 a.m. Do you have any questions at this time? Yeah, one's a final pretrial, one's a jury trial.
Okay.
Okay, any additional matters for the record?
Nothing for the people.
Nothing for the defense. Thank you.
You're all set, sir. Thank you. Jasmine Flowers. On the record, in the matter of the people of the state of Michigan versus Jasmine Flowers, file number 20-03685. Counsel appearance.
The prosecutor, Kate Kosowski, on behalf of the people.
Assistant Public Defender John Lee on behalf of Jasmine Flowers.
Today was the date and the time that was set for a free trial for unlicensed dog. Was there an offer on this?
It was my understanding, and I've been provided proof that defendant is no longer in possession of the dog, so we would be dismissing this file for compliance.
Motion to dismiss is granted. You're all set. On the record in the matter of the people of the state of Michigan versus Douglas Shipper, file number 23-03391. Appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Mr. Shipper present. He's failed to appear. Bench warrant will issue.
If I can ask real quick, has the court received an appearance filed on behalf of Mr. Shipper? Okay, I just want to make sure that our office was
correct. We don't have one.
Thank you.
We don't have his fingerprints either.
Okay.
On the record in the matter of the people of the state of Michigan versus Manuela Scherer. File numbers 23-03-482838485. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Manuela Shearer.
Okay, Ms. Scherer is present via Zoom. Today was the date and the time that was set for pre-trials. I have 1, 2, 3 dog license vaccinations and 1 dog at large. How are we proceeding?
Your Honor, Ms. Shearer has informed me that she has in fact taken legal measures to fix the dog at large. She has not yet provided any proofs. I have talked with her about the necessity of that, and we have set up an email exchange where that will happen. She does not yet have the dog's license. She is in the process of making appointments to get them vaccinated, and that will proceed. So we are asking for an adjournment to allow her time to complete the licensing process and to forward the proofs regarding the dog at large remedial measures.
February 6th at 10:30.
Yes, ma'am.
Do you have any questions for the court?
No.
Any additional matters on this file or these files?
Nothing for the people, Your Honor.
Nothing for the defense. Thank you.
You're all set, ma'am.
Thank you.
You're welcome. Record in the matter of the people of the state of Michigan versus Noel Jackson, file number 23-00617. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Noel Jackson, who is in the courtroom in Simmons.
Okay, we have an interpreter present.
Yes, I'm present, Your Honor.
Okay, why does your video never work when you log in?
I tried to open it, but I still have the issues. My computer dropped down recently, and I still have some issues to be fixed. But I can only hear you and see you.
Okay, well, I need to see you in the future, okay?
Yes, ma'am.
Please raise your right hand.
Yes.
Solemnly swear or affirm the information you're going to translate will be translated completely and accurately, not divulging confidential communication, so help you God.
I do, Your Honor.
Thank you. Today was the date and time set for pre-trial.
Uyu munsi turi hano kugira twumve urubanza ku nshuro ya mbere.
Matter was adjourned for a sobriety court screening.
Hanyuma urubanza rukaba ruzoherezwa aho abashinzwe gukurikirana bafashe ibinyobwa cyangwa se ibisindishwa muri sobriety court mu rurimi rw'ikizungu.
We have an update.
Your Honor, the issue that we have been having with 54B in regard to getting people screened that are in need of an interpreter also applies to Mr. Jackson. Per our discussion yesterday, it is my plan to explore whether or not 54A has room in their sobriety court for Mr. Jackson, and or see if I can work with Ms. Petrosky to find an adequate solution.
Nyakubahwa, icyo nashaka kugira nongereho ni uko twari tukifite ikibazo cyo kuntu twashaka umusimuzi ugumaho udufasha kuri dosiye ya Jackson, nicyo kintu twari tukiganiraho.
February 20th at 8:30. Pre-trial.
Your Honor, would you repeat for me to me? Did you say February 8:30?
February 20th at 8:30.
Hanyuma tukaba tuzagaruka hano mu rukiko mu kwezi kwa kabiri tariki 20 saa 2:00 za mu gitondo.
You have any questions?
Hari ikibazo cyaba gihari?
nyine nzagaruka hano nyine muri office nanga hari ahandi nzajya.
So will I have to come at this place here or will I have to go somewhere else?
We'll come back to this place.
Ni hano uzagaruka n'ubundi.
Any other questions?
Hari ikibazo kindi waba ugifite? No, thank you.
Thank you. You're all set.
Your Honor, thank you so much for using your service.
Thank you. On the record in the matter of the people of the state of Michigan versus Marlon James, file number 23-03143. Is Marlon James present? Okay, big short will issue. On the record in the matter of the people of the state of Michigan versus Nikki Marie Lopez, file number 23-03638. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Nikki Marie Lopez.
Okay, first and foremost, Ms. Lopez, are you supposed to be on GPS tether?
Yes, I am.
My records reflect that your tether has been cut off since the 18th of December. I'm issuing a bench warrant to revoke your bond.
I have it on currently. I've had it on from.
Have you been paying the bill?
There was no bill to pay.
As defendant not complying with bond condition, tether has been shut off since December 18th. It's a notification that the court received.
Okay, I got a email confirmation saying that I didn't have to pay.
Okay, well, I don't know why it's saying that did your battery die?
No, I have it on right now.
You need to report in person.
Okay.
Because I'm going to, and I need you to report today, otherwise I'm going to revoke your bond. Because the notification the court received, and we've received more than one, was that your GPS device remains dead since December 18th, 2023. Ingham County Indigent Funding Program was paying for your monitoring fees. They requested that I allow them to cease paying for it because your device is dead.
Oh, I never received any notification of that. It must be
No
something.
notification that your device, let me see your device.
Okay, sure.
When's the last time you charged it?
Would have been this morning. around 8 a.m.
Okay, you need to contact pretrial services and the electronic monitoring service, but I need you to report today in person to confirm that. Otherwise, I'm going to issue a bench warrant. I'm going to reset your pretrial as well.
Okay, so I would have to go where to report?
You need to come to, you contact the monitoring service first to make sure your device is being properly charged and that it's functioning properly.
Okay.
You also are going to appear to 54A District Court today.
Okay.
February 6th. I'm going to reset your pretrial to February 6th. At what time? At 9, and we'll address the issue of your bond when you appear today, okay?
Okay.
Thank you, counsel. You need to appear with her. On the record, in the matter of the people of the state of Michigan versus Holly Vance, file number 23-02618, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Holly Vance.
Okay, Ms. Vance, today was the date and time set for pretrial on a dog no license. How are we proceeding, counsel?
It was my understanding that I've been provided proofs that defendant has, is now in compliance on both dogs. She's given one away and licensed the other dog, and both dogs were vaccinated. So the people would be dismissing this case.
Motion to dismiss is granted. You're all set, Ms. Vance.
Thank you so much. Have a great day.
Same to you. Ms. Lopez, you're free to go so that you can make your way here after contacting the tether company.
All right, thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Matthew Wolf, file number 23-03207, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Rowley on behalf of Mr. Wolf.
Okay, Mr. Wolf, I don't see that I have your fingerprints.
Oh, they should have them down there. I've did fingerprints a lot of times.
I recognize you do, but every time you have interaction with the court, you need new fingerprints. So that's why you do them a lot of times, because you probably interacted with the courts multiple times. But I need them on this file. There was an order that I issued on this file for your fingerprints, and so I need them this week. Okay. Get that taken care of.
I will, Your Honor. I'm sorry.
Which day are you coming in this week to do that?
I could, hold on. I could do them this Friday. This Friday.
Okay, I know here that you'll come in by Friday to get your prints done. This is a driving while license is suspended. Was there an offer?
There is, Your Honor. Our offer would be to have the defendant plead guilty to an added count 2 of allowing a suspended person to operate a motor vehicle. And we would dismiss count 1, driving while license suspended.
It is our intention to accept that offer and enter a plea, Your Honor.
Okay, we'll set it for a plea date.
Okay.
February 6th at 9. February 6th at 9.
February 6th.
Yes, at 9 a.m.
Okay.
Do you have any questions?
No, I don't, Your Honor. No, I don't.
Okay, if you're coming in on Friday and you can get your attorney to log in, we can do it then. Ms. Petrowski should be here.
I will be.
Okay. Any additional matters for the record?
Nothing from people.
Your Honor, we do have a written plea sheet if you'd like that.
Oh, yes, please. You're all set for today, Mr. Wolf.
Thank you.
You're welcome.
You said February 6th at 9 a.m., right?
February 6th.
Yes.
At 9 a.m.
Contact you today, Mr. Wolf.
Yes.
I'll contact you today.
I'll talk to you. Your
Okay.
attorney will call you.
Okay.
Thank you.
Thank
I've not
you.
seen Ellen Boss. I'm gonna issue a bench warrant.
Oh, I get it out of here.
Is Mitchell downstairs? Who's representing Mitchell?
I am representing Mr. Mitchell.
Did you speak with them?
Yes, we have just received the office.
You spoke with them already?
Oh, I thought you said, do I need to speak with him? No, I do
No,
not speak
we don't have
with him.
time to speak. I have the jury.
Okay.
I don't have time for everybody to speak with their attorneys in the middle of a docket. We don't exchange offers before court.
We have not had an opportunity to talk about Mr. Mitchell specifically because there was this outstanding issue as to whether or not his case was supposed to be dropped. And she has just found the resolution to that.
Well, I mean, in general practice, because there was a lot of exchanging of offers today and a lot of talking to attorneys or to the clients today. So I'm trying to understand what is the general course. Are offers exchanged before?
In some circumstances, admittedly not in all of them. Your Honor.
Okay. Because was read it over, we have to get it taken care of. I do have, the jury has been here for over an hour, so I need to bring them up. So you're gonna have to go down and speak to him.
Okay.
And then we can bring him up at some point today. I don't know that it's going to be right now because I'm going to bring the jury in right now.
Okay. Thank you.
Thank you. Let's see. Okay, let's see. I did not get anything other than this for juries. Did they? To the jury panel, did we get those? The jury book and panelment forms. I just got a list, but I didn't get